So let's start from CITES, and you've heard about this treaty before, so I assume some knowledge of it. And I think what I'd like to explore with you in the time we have is rather the dynamic nature of the regime itself, as well as of its compliance procedures. And interestingly enough, this is a convention that has shown incredible vitality. It has started from an understanding that its main core business was really looking at international trade in specimens of wild species, but then really very much with the idea that this would be shipped individually. And now I think the realization is that things are much more complex. And in fact, the convention is looking much more into trading commodities and how different products based on endangered species need very much to be on the radar screen of the convention, in addition to more perhaps traditional forms of trade. And again, if we look at the treaty itself, we don't find any provisions related to compliance. Those were early times, and that idea that also practice and trend wasn't quite there yet. But that has not stopped the convention from evolving in a way that has actually led to the creation of perhaps one of the most complex compliance regimes, with several layers and procedures attached to it, and with the exciting feature of having also a possible imposition of trade sanctions on parties, which is one of the exceptional cases in the landscape of international environmental law. And interestingly enough, all the bodies that form the governing structure of the treaty are very much involved in compliance. The Conference of the Parties, but the Secretariat is very key and very proactive. The scientific committees, as well as the standing committee, they're all involved in not only supervising work by parties, but also very much monitoring national action and proposing action, including if certain progress has not been shown, and very much as a last resort, possibly trade suspensions. And this is something that then, of course, goes to the Conference of the Parties and relies then on majority voting. So another quite distinctive feature of the convention that allows for the imposition of sanctions against most likely the will of the country, the receiving end, which in other regimes would be perhaps shielded by the consensus-based decision-making approach. So there are two procedures related to compliance under CITES that are worth looking into more details. And you've heard, I think, already at the start of this course about the National Legislation Project. And that's in fact something that's quite unique, incredibly well developed. And while it has this unique role for the Secretariat to assess and grade national legislation on the basis of expectations and clear requirements in the Convention, it also has a very strong assistance component. Now, so on the teethy part of it, we can see that since 1992, the Secretariat has used some of the more broadly framed powers within the Convention to be quite systematic in looking at the adequacy of national legislation. And this grading system is really based on whether legislation meets all, some, or none of the requirements in the Convention. I mean, once again, such a let's say, powerful role for the Secretariat is possible because the Convention is quite specific about what needs to happen in national legislation for the Convention to be actually implemented on the ground. And so you have 4 criteria which can be derived from the text of the Convention, and the parties could agree in terms of these are the key elements that need to be there. There's no discussion about it for CITES to be implemented. So the designation of a management and scientific authority, clear prohibitions in the law about trade in specimens in violations of CITES, the penalization of the trade, and confiscation of specimens that were illegally traded or possessed. So those 4 key elements need to be there. Now, what happens if a country finds itself in one of the lower grading, let's say, according to the Secretariat assessment? The idea is for it to develop a legislation plan, so identifying what are the steps that are needed to bring national legislation in line with those 4 minimum criteria, and also agree on a timeline for, let's say, to show commitment to the realization of those agreed steps. Now, if that plan then is not realized, this is where the Secretariat can suggest the use of sanctions, but there is, of course, an understanding that legislation doesn't change from one day to the next, and there may be also challenges at the national level. They may go beyond what is can reasonably be expected to be quickly solved. So the Secretariat wouldn't go ahead with proposing sanctions if there is evidence of good legislative progress. And what that means is that with the legislation plan, we have a structured dialogue with the Secretariat about what are the areas in which national legislation is falling short, and an ongoing structured dialogue in the follow-up, and an understanding and some agreed criteria about how the country can gradually be brought into compliance. All of this, however, does not uniquely fall on the shoulders of individual parties, and the Secretariat has been very, I think, inventive in developing a whole series of tools to support progress in national legislation. It has developed a manual and checklists. It provides for, upon request, it can review draft legislation and provide advice. It has also carried out workshops and worked with other organizations, particularly when the convention and the species listed were moving perhaps in particularly specialized areas. So think about timber trade, or more recently trade in commercially harvested marine species, so the fisheries sector. I've actually been involved in some work with CITES and the Food and Agriculture Organization, bringing together respective expertise on the development of CITES compliant legislation and development of fisheries legislation, and seeing how even more specific guidance can help in really understanding when a CITES management authority needs to talk with particular authorities under the fisheries management regime within a country, and how all the different aspects of regimes that are at the national level usually separate needs to work with each other. So quite an intense activity, in some ways like the poster child of compliance in terms of national law development, and something that again is very active also in terms of further developing the type of support, including technical support to countries, and really taking stock of the fact that as the convention develops and new challenges are brought on the table of CITES parties, then also the support from the Secretariat needs to become more and more targeted to these new challenges. The other layer of compliance procedures is instead much more to do with actual impacts on the ground of the convention, and it has to do with trends and statistics about trade. So on the basis of the information the parties provide to the Secretariat, there is a possibility to basically match information about exports of certain CITES listed species under Appendix 2 and what is happening to them once they leave a certain country. And the matching and cross-checking of that data, statistical data, has allowed the identification of potential areas and countries of concern. And this is work that the Secretariat is not doing alone. In fact, it relies quite a lot on the UNEP World Conservation Monitoring Center, where all this data is analyzed, and a public registry has been created. And it's very much an area that actually originates from work of an NGO and still remains very much reliant on the work of traffic, which helps to analyze that the data and identify areas where perhaps illegal trade or unrestricted legal trade may be happening. So all this is another way to look at the actual trade occurrences, and whether or not by the matching of data what different CITES parties are doing, there seems to be problematic areas. Now, what happened with that is then either the Secretariat, but also it can, of course, arrive to the Conference of Parties, the standing or the scientific committees, may all look into the reasons and the understanding for those potential areas of non-compliance, and may suggest different measures to countries as to how to, well, first identify whether a problem is really there and then how to address it. And I think the level of detail that is discussed, I've been sitting in some of the sessions of the scientific committee, for instance, is quite incredible. I put a picture up there. This was from a presentation by Mongolia on Saker falcon protection. And some of the measures go well beyond what you can imagine in terms of border controls and better training of customs officers. In this case, one of the issues that was part of the a puzzle of reasons why a certain species was endangered by trade had to do with the protection of its habitat and the absence of resting spots for it. And the creation of this artificial nest, very low-key, low technology, was quite discussed in depth during the scientific committee as one of the key elements that actually allowed Mongolia to make a lot of progress in terms of compliance with this species. And what you see is, again, an ongoing dialogue, a very detailed dialogue, and an ongoing dialogue where then the scientific committees also follow up and continue to monitor action by different parties, but where also other parties are very much able to learn from each other, follow progress, and with also the let's say, the advantage or the opportunity for the Secretariat and the technical bodies to also suggest alternatives with a view to bring wildlife trade back to sustainable levels. So very high degree of technical support, a very structured and in some ways data-intensive approach to compliance.